lack of recollection. In other words, she is recanting. So this is not, and what's important to realize is this is not about determining whether we have a witness who is being honest or not. I think this rule contemplates a witness who may be being dishonest by recanting. And the issue is not whether or not the witness is being dishonest, and in the interest of justice we want to put in what we believe to be a more honest statement. The question is whether or not you're putting up a witness to impeach them. Putting up a witness to introduce a statement previously made from which that witness has receded, or which that witness has recanted, which is what's going on here. And the rule is clear on that. Can't do it. It's hearsay, and it should not be permitted. Any issue with respect to whether or not the statement is sworn or not, I think sworn statements typically contemplate an adversary having the ability to test credibility at the time it's made. Furthermore, this witness, when asked by the state, did you give an honest statement to law enforcement back in 2018? She's like, I don't know that I did. She posited the possibility that she could have been lying then, which further undercuts the indicia of reliability. She also said she felt threatened then because she was speaking, given that she was advised that her, and I think advised in bad faith, that her daughter might be charged as an accessory after the fact, when there was no evidence to suggest that. And she said she was acting then under threat, and that she's not certain whether she was being honest then. So for the state now to say, hey, she's having a failure of recollection, so we just want to read her prior statement into the record, is a pretext. And it runs in violation of the law in the state of Florida